Information contained on the following program off the record does not constitute specific legal advice for any real case. Off the record is presented for entertainment and general information only. Listeners are advised to consult an attorney for their specific legal questions and guidance, and not to rely solely on information presented on this or any other law program.
It's time to go off the record. Need insight on how the law works? You found the right place. Legal questions, you've found answers. Thanks for joining us. Off the record. Here's attorney Julie Jordan de Palma.
Well, happy weekend. And I emphasize happy weekend because the sun is out. It is getting remotely warmer. It looks like spring may actually be here.
Before the end of the day, though, snow showers and squalls and limited visibility.
You stop it.
Just kidding.
Stop it. It's beautiful out. I am so thankful. I was born in the springtime. I love the springtime. I love when it finally gets warm.
Yeah.
I feel like a whole new person today, which is going to help the show because I won't lie. We've been talking about some darker topics when we talk about powers of attorney and people needing guardianships. And today we're also going to talk about appointing administrators for estates and probating wills. And so I'm glad that the sun is shining because we'll try to see the positive pieces of this, even though sometimes difficult circumstances lead us there. So it's nice to be back with everybody. We have been taking a couple shows now to make a bit of a series to talk about powers of attorney, living wills, healthcare proxies. We started to talk a little bit about the New York State Article 81 guardianship last time. It got towards the end of the show. So I'd like to finish that up today. And then I'd like to get us into an introduction for getting administrators of wills, letting people know what that means, talking a little bit about the questions that most people have initially, which are the most basic. How long does this all take? So let's talk a little bit about time frames and reasonable time frames and what happens during those time frames so people can make good decisions and be prepared, because there's nothing worse than needing something, being concerned about something, and for people to not have the right expectations set, and that can sometimes make communication difficult and becomes very frustrating. So I think it's good for people to know average time frames so they can plan and be prepared for that. So last time we started to talk about the Article 81 guardianship in New York State. So what is that? That is where a court can appoint a guardian for someone whose personal or property needs need management and assistance. And that's generally because the person is deemed incompetent, incapacitated. It is after a hearing is held or the alleged incapacitated person consents and says, I need that help. So what we started to talk about last time is that I think people have concern about that guardianship proceeding because they are worried that their family, they're worried about a document out there that says someone's incompetent or incapacitated. That is not something you take lightly. And they're worried that what happens if circumstances change, this feels very permanent. And it is true that the Article 81 guardianship lasts for the life of the incapacitated person, but there are circumstances where it could be modified or it could be terminated. And so what I want people to realize as we talk about this topic is that courts don't take this lightly either. And so they're not going to give powers or abilities to a guardian beyond that which is really necessary. And if circumstances change, the idea is always to have the least restrictive powers in place as needed for the person to protect them, but not so much that goes beyond what they may be able to do or could be able to do at some point. What I wanted to get into a little bit more today is just how do you do it? We talked about what it was, we talked about some of the standards, but I want people to just have a better sense of how do you actually go about that process? How would you start it? How would you start to look at these questions? So the first piece is really to sit down and have a realistic look at what does your family member, loved one, person that resides with you, someone in it who has an interest in an estate, what do they need? So when we talk about personal needs, what are we talking about? We're talking about things as simple as ability to get groceries, feed yourself, cook meals, get yourself dressed, care for yourself. It's also safety issues. Can you take care of your home? Can you do that upkeep? Can you clean the home for yourself? All the personal hygiene things, feeding, all the things you would think of. Your personal day-to-day needs. How are you getting through your day? Then there's also the property needs. And property needs are not just physical property. Do you own property, land, a house? It's also your bank accounts, your checking accounts. Can you pay your bills? Can you have those necessary discussions? Do you know what your finances are, what the state of your finances are, how to budget? And for people who have various either cognitive disabilities, whether that's because of a progressive disease like Alzheimer's or dementia, or if that's a developmental disability, or a cognitive disability, a neurological condition, what have you. Those folks, a lot of times one of the first things you see is this inability to do basic arithmetic and math and plan and budget. And so those are the types of things that you want to sit down and say, okay, what's going on and what am I starting to see? Then you have to take it a step further, because you have to be able to show that without some assistance here, this alleged incapacitated person, that there is a likelihood that they may suffer harm. And how do you show that? Well, for example, if the person cannot budget or pay bills, or has missed bills, or is getting an inordinate amount of fees on accounts because things aren't being managed, for if they have various benefits that they aren't able to, for example, apply for those benefits or recertify for those benefits, and there's a risk of not having funds, means to support themselves. Those are all things that you would be able to point to and show as there is a likelihood of harm here. Something could happen.
Quick anecdote, the case, again, of my uncle who had Alzheimer's, a 30-year onset, by the way. Right. And my aunt is walking past his car, which was parked in the parking area at the little retirement community where they lived in Florida, and there was his checkbook on the hood of the car. So Aunt Carmen picks up the checkbook and says, first of all, it's not good that he left it on the hood of the car, but let's find out what's going on here. Discovered $23,000 in the non-interest-bearing checkbook, the checking account, the book for which was left on the hood of the car. That
is correct. And those are
see what
the
happens?
Types of things that make family members' heart stop, right? Because you want... it's such an emotional piece, too. I don't want to lose sight of that. Sometimes we talk about legal issues, and we're talking about the practicalities and day-to-day and how do you touch these bases. But, I don't want to lose sight of the emotional piece that comes into this, because so many times you have somebody that is competent and has been competent for so long and intelligent, and somebody that provided for a family, particularly when you're talking about parents, and having that moment where, you walk up to the hood of the car and there's the checkbook. That's the moment that, for as long as you're trying to give people their independence and help them and care for them, and I think we let things go for a while, right? Because there's that pride piece. We don't want people to feel that we're interfering or that we're being disrespectful. We want to try to do it in the time that they can accept what those changes are. But those are the moments that it feels a little like your world's crashing down around you.
You've been with somebody for 30, 40, 50 years, too. You don't want to see that. That's the kind of thing that you just do not want to gaze upon. So you're going to have a denial factor probably internally of some level.
Well, there's no question. And what comes to with that denial factor is the other piece which creeps in, which is the fear piece. Oh, boy. If it's on the hood of the car, and what else is going on? What hasn't been paid? What hasn't been renewed? What isn't being taken care of? What do I not know that might come out of the woodwork and hit me in the face? Those are all very difficult and delicate pieces. And anytime you're talking about these things, I brought this up in one of the last shows, trusted advisors in your life. Who are they? The point of all these shows has been about planning and finding those trusted advisors that you not only know can do competent work for you and give you good advice, but who you want to work with long term, and who get to know families and people so they can help you through these situations in a way that is both appropriate professionally, but also delicate and respectful. And they can do that. There are certainly ways to go through these processes where, for example, in the guardianship context, people feel badly about what they have to do. They know it's required, but it's still a painful process. And there are ways to handle that I think people should know. Attorneys, court evaluators, the judges that help with these proceedings are very sensitive to those issues. They're very well versed in it. They certainly have a lot of experience dealing with families, and everyone really does work together as best they can as a team to look out for that person and handle it in the best way possible. Sometimes alleged incapacitated persons, as a side note, when those hearings happen where attorneys and court evaluators are presenting to the court what's needed and what the likelihood of harm is, sometimes the alleged incapacitated person is at that hearing. Sometimes there are situations where they don't need to be there and that can be waived. For example, if they really can't participate because they are incompetent or incapacitated. But the other piece is that those hearings don't always have to happen in the courtroom. For example, if someone is in a facility, whether it is a nursing home or a hospital, those hearings can be brought to the alleged incapacitated person too. So if they are in a position to participate and provide meaningful input, there are ways to do that. They're not just left in the cold if they can be part of it. So those are all things that can be taken into consideration. So if you do this and you're looking for an attorney, ultimately, where is this going to happen? It's going to start with papers being filed in the Supreme Court where the alleged incapacitated person resides. For those purposes, if somebody's in a facility, for example, a nursing home or a hospital, they are deemed to reside where that facility is, so the county where the facility is. It can also be brought in the surrogates court, where an alleged incapacitated person has an interest in an estate proceeding. And it's brought by something called an order to show cause, which is a type of paper filed by attorneys to put the court on notice that they need assistance. They need help with something. There is a notice that goes along with it to talk about who the person is, what is being asked for, who's interested in it, to give them notice that this is going to be happening. And then there's a petition which goes through what the person needs, property management needs, what's being asked for, why there's a likelihood of harm, what the medical records or background information shows to demonstrate what those needs are, and in comparison to needs and likelihood of harm, what are the available resources currently available and why are they sufficient or insufficient to help this person?
So the issue framing here is, you mentioned it's a hearing to show cause. And so what we're looking at is show why this person should not be found in need of a guardianship or some conservatorship.
Right, and so to be
kind of a burden shifting thing.
Well, to be clear, the way that it starts is with an order to show cause, as opposed to, for example, a notice of motion. So the order to show cause is a way to get faster intervention, I guess would be the best way to generically explain that to people who aren't attorneys and using the court system. And what it does is it gets a judge to quickly sign an order that can be in place for a limited period of time until this hearing can be scheduled and a full hearing is held. And then at the hearing, the person bringing the petition has the burden of showing that the person needs this assistance. So the order to show cause is just that first piece to get a clock rolling and a hearing scheduled so that things can be moving. Because as you can imagine, much to your point of the story of there's a checkbook on the hood of the car.
Yeah.
When you realize that somebody really needs help, it's usually because you've started to notice some of the dominoes tipping over and you realize there's a problem and people want to act quickly to prevent further injury.
Right. Imminent threat.
Absolutely. So when we get back, we're going to start to dig into who can bring these proceedings, who has to be put on notice, some of the time frames, and then as we move on, we're going to get into administrators of estates.
Thanks so much for joining us off the record. That's Julie Jordan DePalma, and she's the host of the show. We'll be right back on WYSL.
26 years, it's been the late winter break, the early sign of spring that brings a smile to the face of every member of the family. Folks all over the Northeast wouldn't miss it. A visit to Cartwright's Maple Tree Inn, nestled in the forest outside Angelica, New York. If you haven't discovered this special destination, you don't know what you're missing. The Maple Tree Inn specializes in just one thing: buckwheat pancakes served family style and topped with the Cartwright family's signature maple syrup from thousands of taps in the maple grove right outside the restaurant. Eggs as you like them, maple milkshakes, and the Cartwright's own seasoned sausage are great accompaniments. The rustic setting and the scenic trip to the Maple Tree Inn are all part of the fun. Find out why families regularly make the trek from Rochester, Buffalo, all over the southern tier, even Canada, Germany, and Japan, just to experience this sweet treat. Cartwright's Maple Tree Inn. They're only open February 13th to April 15th. Call 585-567-8181. Get more information and driving directions at cartwrightsmapletreeinn.com.
At University Eye Specialists, I see many patients who suffer from dry, irritated, or itchy eyes. Sometimes these symptoms are often due to severe dry eye. Over-the-counter eye drops often help, but sometimes dry eye may require treatment with prescription medication. Dry eye is a very treatable medical condition that should be taken very seriously. The health of your eyes is very important to us. Please feel free to call any one of our local offices for an appointment.
In America, we are living longer, healthier lives. The longer we live, the more likely we are to develop eye conditions such as glaucoma, macular degeneration, and diabetic eye disease. If you are over the age of 40, it's important to have a thorough eye examination in order to identify vision-threatening conditions at an early stage. At University Eye, we have the technology and experience to screen for and to treat glaucoma, macular degeneration, and diabetic retinopathy. At University Eye, your vision is our mission.
Phone 1-800-724-0938.
Suffering a serious injury because of medical malpractice, nursing home neglect, dangerous conditions on property, or a car accident can make your life feel like it stands still. How will you provide for your family and overcome this loss? I'm Julie Jordan De Palma. I'm a trial attorney, but I'm also the daughter of someone who suffered a disabling injury. When you need someone to provide compassionate guidance to your family, but be a fearless advocate to your opponent, call the law offices of Jordan De Palma at 585-673-3053.
A healthy smile has general health benefits beyond just teeth. It's whole body wellness. Don't live with broken, missing, or failing teeth. Lakeview Dental can restore your smile with state-of-the-art dental care. And if you've been afraid to go to the dentist, those days are gone, thanks to safe, fear-free sedation dentistry. Find out more at livoniasmiles.com or call 346-3028. Lakeview Dental, for the smile of a healthier you.
You're listening to Off the Record with Julie Jordan De Palma on WYSL 92.1 FM at 1040 AM.
So we're back together with you, and we're trying to focus through the sunshine, which is not easy because we haven't seen it in so long. So during our break, we're talking about fun cars and convertibles. And
convertible weather.
And
we discovered, counsel here, and I've discovered that in our families, we each have Pontiac Solstices.
Which I love in our family. My husband has a beautiful dark navy blue one that makes him very happy. And I joked during the break that other than my children, maybe me, but probably not. I'd like to say so, but I'm not sure, to be honest. I think that car makes him the happiest.
They are happy little cars. They're a lot of fun.
So for those who may have fun cars, I hope you get out to take a drive. I know ours is coming out of storage soon. Yours is out already?
Apparently. I just got a picture from Mrs. Savage saying, "Thank you for my ride, my love." And there it is. So obviously it started for her.
Good for Mrs. Savage. I love it.
Maybe she put I have a little battery charger that I mounted in the garage. So maybe she had the presence of mind to go out last night and plug that in to make sure that bad boy was ready to go this morning.
Well, our dear one is out in storage in Sodus and will need to be picked up. But I understand that beginning of May, that trip is happening.
Yeah, as soon as you get a little bit of rain like we've had, and it washes the salt off the roads, that's a good thing.
Time to go.
Then I have my own toy, which is out in the garage here at the radio station, which is a Chrysler Crossfire.
Come on. What color is it?
It's gray. It looks like
When's it coming out for showing?
Actually, it's over at Mollier in Honeyway Falls right now, having a power steering leak fixed.
And I bet they're doing a great job.
Oh,
Are they
great.
friends of yours?
Oh, yeah. They're advertisers on the station.
Yeah, let's do plugs.
They
We
always,
love everybody.
They always say yes. And well, yeah. Whatever that means. I don't know what that means, but they always say yes.
They say yes to sunshine and cars that work great, so we can all have a nice time. So we're going to focus, but get out into the sunshine, get the fun cars out, take a nice drive. It helps clear the mind for things like planning for the people in your life, which is what we're talking about today. So we were talking about guardianships for those who might not have been with us for the beginning of the show, and we're moving on with that. What is the guardianship? It's something that can be put in place with a court order to get assistance for someone, appoint somebody to be in charge of their person and property. So when we left off, I wanted to get into who can do this, who can actually bring this petition to the court to help someone. Well, first of all, an alleged incapacitated person can bring it for themselves if they are competent enough to bring it and yet know they need assistance and could be in likelihood of harm, or they have a condition which may progress and make it more difficult over time. They can actually bring that petition themselves. A distributee of that alleged incapacitated person's estate. What does that mean? For example, that could be a spouse, a parent, a sibling, a child, etc. An executor or administrator where an alleged incapacitated person may be a beneficiary. That person could bring it. A trustee of a trust where that alleged incapacitated person is a beneficiary. A person who resides with the person. Corporations and public agencies can also do that. In other words, if they have some type of interest in the alleged incapacitated person and their property, they could bring it to try to protect those things. The CEO of a facility where an alleged incapacitated person resides can also bring this petition. So what's an example of that? If someone is in a nursing home and they may not have family or relatives nearby to assist them, that would be a situation where a CEO might step in. Another situation might be in the context of a hospital where someone is an alleged incapacitated person and they may not have some of the documents in place that we talked about, powers of attorney, healthcare proxies in particular, or there isn't somebody that is available immediately available that's appropriate, that can have the competency themselves perhaps to make those decisions. Then the CEO of facilities can do this. When you start this type of proceeding, you have to put certain people on notice. In other words, this isn't a secret. It's not something that is done behind closed doors. It is a public proceeding, and you have to put various people and organizations on notice of it so that they have a full and fair opportunity to be heard. So who is that? Spouses, parents, siblings, children of the alleged incapacitated person. Someone who resides with the person. Any of the agents, for example, if an alleged incapacitated person did have a power of attorney in place or a healthcare proxy, those individuals who are the named agents in those documents have to be put on notice. Any person or organization with an interest in that person or their property. So that might be a facility, it might be a hospital where the person is at that time. If they're receiving benefits, Medicaid benefits, for example, social services would be another organization, entity that would have to be put on notice. So what's one of the first questions people ask? How long is this going to take? There are time frames that are spelled out for this. So before the break, we were talking about one of the ways you get this started is with something called an order to show cause, to put the court on notice that you need assistance. And a judge signs that order. So within 28 days from a judge signing that order to show cause, a hearing has to be held to discuss the person's needs. Once that hearing is held, within 7 days after that hearing, a judge has to issue a decision, unless they can show good cause why they can't issue it yet. What's an example of what good cause could be? Sometimes there's an additional medical question or concern, or an asset hasn't been identified, or the court has a follow-up question which wasn't presented during the hearing, and the judge may ask the parties to follow up on that so that the judge can make a good decision for that person's best interest. And again, because this is something that's a last resort, if there is any significant question like that, where papers need to be amended or subsequent hearings need to be held, that might hold you up. But otherwise, within 7 days after that hearing, you need a decision. Then 15 days after that decision, a commission gets issued. What is that? Generally speaking, that's the piece of paper that says you're the guardian, you've been appointed, you are commissioned to be that guardian and protect this person. So those are the basic time frames. So you're looking at 50 days roughly on the outset of how long that could take, 50 to 60 days. So it's not overnight, but it's also not a year. It is a much shorter time frame as court systems go. Let's put it that way.
There's no immediate relief available in the event of some imminent danger to person or property that you can't get that kind of relief.
Well, the order to show cause is the first piece of this that gets signed. And so generally speaking, if there is some very significant immediate harm, you would be putting in your order to show cause that a limited power for a very specific time frame needed to be granted until a full hearing could be held to try to prevent that issue. And so the order to show cause could help you do that as you're going through the next 28 days for a hearing, 7 days for a decision.
Right. I'm thinking about something that's analogous to a TRO, a temporary restraining order.
Well, and it's kind of, again, in the order to show cause, you could put some of those limited powers in place or put somebody in for a limited period of time to make sure that somebody wasn't getting hurt or damaged more or in addition while you're waiting for your hearing to be scheduled. And then again, if there really is a situation like that, in addition to that order to show cause being signed, generally speaking, the attorneys would be calling the court and a clerk to let them know about that immediate need. And courts really do everything they can to try to get things scheduled quickly if there's a situation like that. The thing that's going to hold you up is before you bring this, you're going to have to give everything that you need to give to an attorney to assess what is going on. And the attorneys can't do that by themselves. So if there are medical records needed to prove why this person needs assistance, or there is a particular doctor that may need to be called in because the records aren't clear, well then there is a portion, obviously, that you're a bit of a slave to. How quickly can you get those records, and how can you coordinate with any particular doctor that may need to be called in? So, there's always variables, but there are ways to protect from that immediate harm even before that hearing is held.
It would occur to me also that you want to pick the right attorney, somebody who is well-versed, experienced, and competent to handle these kinds of issues.
Right, and the Article 81 guardianship, and what I tried to let people know in some of these different shows, there are certainly documents that you can do on your own. You don't need to hire an attorney to do a healthcare proxy. You may or may not need to have one for a power of attorney. I would recommend that people do that because those are a little more difficult. But absolutely, definitely on an Article 81, you should be looking for an attorney to assist you with that because there are too many requirements and hoops, essentially, that have to be jumped through properly to get this put in place and fully protect someone. So it's not just any attorney. You do want to do your research and find someone that is well-versed in doing these and has done them successfully who can help you.
What are some of the buzzwords they should look for? If you're out there looking for an attorney, do you research this through the bar association locally, or?
You can. One of the ways you can do it is to call up whatever county bar association you're in and ask for a list of their estate attorneys. Nowadays everyone has websites, so you can dig around on their websites a little bit to see what they're able to do and can do. Another thing you can do, there are things, for example, something called Find Law through Thomson West, Thomson Reuters. It's a big company that assists attorneys with research, and they also have an arm that allows you to search for example, if you put estate attorneys or guardianship attorneys in Rochester and Syracuse and Buffalo, whatever, in there, you will likely pull them up. They'll give you some names of those folks who can help you. But what you want to be looking for is an estate attorney. You want to be looking for the word guardianship, who can help you. And specifically, you're looking for that Article 81 guardianship if you're in this situation.
And again, that's findlaw.com. Is that the
You can
URL?
go to findlaw.com. Certainly, if you're in Monroe County, you can go to the Monroe County Bar Association. They have a phone number you can call. They're lovely people. They'll help you get names of those attorneys and make recommendations. All of the local bar associations are great and have people who can help direct you to make some of those first calls.
The voice of Julie Jordan DePalma, Esquire, of the Jordan DePalma law firm, and we'll be back on Off the Record on WYSL.
Insulation. It's a smart idea since it keeps wind from whistling right through your windows, summer heat from your attic from baking you alive, or cold floors in the winter from turning your toes blue. And maybe you know that Icynene foam insulation is the best smart idea since it gets into spaces other insulations can't touch. Icynene fills small openings and gaps in your walls and around windows and doors that add up to big heating and cooling savings, as much as 50%. But the experts at Birch Lumber and Building Supplies in Perry want to remind you, no matter how great the material, only proper installation assures you that your Icynene insulation will give you the ultimate in comfort and energy savings. You can always identify a Birch insulation customer, from their comfortable smile to the extra money they enjoy every day from utility savings. Don't trust your insulation project to any here today, gone tomorrow guy with a pickup truck and a sprayer. Call Birch Lumber and Building Supply, Washington Boulevard in Perry, 237-6128. Do it today and start saving.
Suffering a serious injury because of medical malpractice, nursing home neglect, dangerous conditions on property, or a car accident can make your life feel like it stands still. How will you provide for your family and overcome this loss? I'm Julie Jordan DePalma. I'm a trial attorney, but I'm also the daughter of someone who suffered a disabling injury. When you need someone to provide compassionate guidance to your family, but be a fearless advocate to your opponent, call the law offices of Jordan DePalma at 585-673-3053.
Eyes on Rochester is a full-service ophthalmology office, and we specialize in general ophthalmology, taking care of people from childhood to adult and seniors. We do general eye exams. We specialize in cataract surgery, corneal surgery, and disease, as well as LASIK surgery. We also have a full-service optical shop and contact lens fitting service.
Visit Eyes on Rochester at 1157 Fairport Road.
At Family Furniture in Perry, get everyday savings without big chain store hassles. Find out why Family Furniture is the shopping destination for thousands all over the region. Need a new mattress? Come in and try their all-new Echo Gel infused memory foam, or the solid latex styles for the finest support and comfort available today. Instead of the big Rochester showrooms, shop Family Furniture in downtown Perry, serving you for over 65 years. Open Thursday and Friday nights till 7, Saturdays till 4.
At Finger Lakes Gaming and Racetrack, making you feel like a top dog is what we do. Try your luck on our 1,500 video gaming machines and enjoy Finger Lakes Gaming's award-winning Vineyard Buffet. Or watch your favorite team on the big screen at Remedy Bar and Lounge. Hey, when's the last time you felt like a top dog? Go fetch that feeling at Finger Lakes Gaming and Racetrack, Route 96 in Farmington. And check us out at fingerlakesgaming.com. Must be 18 to play video gaming machines.
We're keeping it legal with Julie Jordan DePalma on WYSL 92.1 FM and News Power 1040 AM.
Well, we're back together. We're finishing up our conversation on guardianships. We talked a little bit about bringing a hearing in order to get someone appointed as a guardian to help someone with their personal or property needs. And so what happens when you're at that hearing? It's really a detailed discussion about exactly what the person's functional levels are, the reason for the request, and specifically what you're really getting at there is what is the likelihood of harm if a guardian is not put in place. You're talking about available alternative resources because, again, this is something that is considered a last resort, and it's supposed to be the least restrictive necessary to protect someone. So there's going to be an investigation of what other additional community or other types of resources are available to help this person. And then it's going to be a discussion of exactly what particular powers are needed and why the proposed guardian is suitable. And generally, while I gave you the list of all the different people who can apply for this, I would say preference is really given to family members, people who are close to the alleged incapacitated person, such that they know best about their needs and wants and desires and their medical conditions and their actual property and asset information. So once this hearing is held and the court grants this person to have a guardian over their person and property, a commission is issued. That's the actual document that gives the person power and names them guardian. What happens next? The guardian has to complete an oath and designation form. So what does that mean? If you are a guardian for somebody, you are considered to be a fiduciary. So let's talk a little bit about what is a fiduciary. A fiduciary has to act in the utmost highest manner of ethics and trustworthiness for that person for obvious reasons. You are protecting all of this person's personal needs and their assets. And what you have to know is that you have to be acting in the best interest of the alleged incapacitated person. Sometimes that is different than what your personal opinions may be. And so that can always create a bit of conflict for people. And that's why it's important to understand the fiduciary means you are doing what is in the incapacitated person's best interest, and most importantly, what is consistent with their own decisions and wishes if they had been competent to make them on their own. So you may or may not want to provide for certain charities for that person. You may or may not want to, if you were doing it for yourself, be in a certain facility or handle medical issues in a particular way or assets in a particular way. But so long as it's consistent with the person's best interests, you also need to be consistent with their own wishes for what they would do if they could do it on their own. So the point is, it's very important that people are complying with those duties day to day, and certainly when you're talking about assets, that they are accounting for what they are doing
and
on a regular
Yeah.
basis, and that they're conserving those assets and using them properly. So let's back up for a second and let's talk about what are some worst case scenarios, because this is, of course, why calls get generated sometimes. What happens when the power of attorney or the guardian isn't doing what they're supposed to do? People get nervous. These people are named, now they're agents, but what's the biggest fear for some people? All of a sudden money is missing, right? Doesn't seem like person is being provided for correctly. Seems like there should have been more assets to do things differently, and people start to dig, and all of a sudden we start to see an issue. Benefits weren't reapplied for. Things weren't certified that needed to be certified, etc. So what do? Your hands are not tied because someone is named as an agent. There are things you can do. So let's talk about the power of attorney context. What happens if all of a sudden you see power of attorney is not acting appropriately? Well, easiest scenario is where the person who gave authority to their agent is still competent enough to say, hey, son, daughter, friend, it seems to me that things are not going as I would expect. It seems I'm missing money, or the bill didn't get paid. I'm getting late notices. What's happening? I need you to show me the checkbook. I need you to account for what you're doing. And they can't. If the person is still competent, you can revoke a power of attorney. How do you do that? You put in writing to your agent, I am revoking my power of attorney to you. You ask for the copy of your power of attorney back. You put the bank, financial institutions, various agencies that might have had your power of attorney on notice that it has been revoked. If you have more than one agent, you may want to also just fill out a new one that only names one instead of two, so there isn't confusion. If you only have one, you are again going to want to probably consult an attorney at that point to double check that you've revoked it properly, you've put everybody on notice the right way, and that you have a new one properly filled out and completed so that there isn't confusion. What happens if the person who gave that authority is not competent anymore? and there's more than one power of attorney. Again, if there's a real concern about dangerous conditions, there's kind of a twofold path. Yes, you can get a civil attorney involved in the civil system to talk about revoking powers of attorney and handling that situation. And again, you're going to want to get an estate attorney who handles these issues regularly to help you with that. Second piece is, if, for example, you're a co-power of attorney and all of a sudden money's missing or something significant like that is going on, obviously you may also want to call the police and file a police report and have proof of that and start to look at your information and get copies of it.
As a fiduciary, you
have a responsibility to do those things. And you're probably also going to want to get an attorney involved too, especially if you know the estate attorney who may have helped you, to report it to them. Because there's two things going on if you're a co-power of attorney in that kind of context. One is you have a duty to preserve those assets and protect the person who gave you that power and handle that agency in the utmost trustworthy manner. And also, from a personal perspective, you're going to want to protect yourself to make sure that no one thinks that you stole the money or that you were the agent that had any wrongdoing. So you're going to handle that piece. You can revoke powers of attorney. There are ways to handle that situation. What about the guardianship? Similarly, the guardian has to act in a fiduciary capacity. If they are not appropriately acting in the person's best interests or consistent with that person's wishes, again, you can go back to the court and you can either revoke some of those powers, you can move to remove a guardian. Again, you're going to want to have your ducks in a row to try to do something like that, because just as the court takes very seriously appointing a guardian, a court is going to take very seriously removing a guardian. And removing a guardian isn't going to happen because one brother, Bob, and another sister, Jane, can't get along, for example. That you don't like the other person, or that you may disagree with the decision they made, is not going to be sufficient to say, for example, that Bob isn't actually acting in mom or dad's best interest, or somehow did something inconsistent with their wishes or outside their best interest. It really has to be a significant issue that gets called to the carpet. But it can happen, and you can handle that situation, and you can remove people. It's not an impossible circumstance.
If you're a co-conservator or co-guardian, you can remove the other party?
You could remove the other party, or if you're not the guardian at all, but you're a family member, or you are interested in the alleged incapacitated person's property you're concerned for them, you can bring a petition to try to remove that guardian and explain what's happening, what is the harm that is happening, such to sufficiently rise to a level of removing a guardian. You can do those things. But obviously, again, we've talked about the situations where you don't really need an attorney. That, again, is a situation where you are definitely going to need an attorney. You're not going to navigate that situation on your own by any stretch of the imagination. So we've talked about all the various scenarios of how do we protect people and what do we do while they are still living. So let's start to talk a little bit about what happens when someone passes away. Where you have a will and you name an executor of your will, that is an easier scenario, right? Certainly once someone passes away, if you have a certified copy of the death certificate, you begin to notify life insurance, retirement accounts, creditors, etc., that someone has passed away. Depending on the size of the estate, you may or may not need to do more or less. So if an executor is named and they are willing and able to serve, sometimes there are scenarios where someone passes away and the executor they named is passed away or incompetent or unable or unwilling to serve. You'd need to get someone new. But if the person is still willing to serve and the assets are very low, sometimes you don't need to do a whole lot. You contact an estate attorney and make sure people are getting paid properly, and it's an easier scenario. If there are more assets involved or more creditors, then that's a situation where you're probating an estate. You are letting the court know that the person passed away. You're getting letters of administration issued. Those are documents that allow that executor named in a will to begin to act in a way to wrap up or tie up that estate. What's that mean? You've got to identify all the creditors. You're going to have to distribute the assets of the estate appropriately. You're going to have to make sure that all the proper tax forms are filed and that tax waivers to make sure nothing is owed are out there. And that's all going to take some time. So when we come back, we're going to talk about some of those time frames that are involved and the reasonable pieces of that process people should be aware of so that they can know how to plan for that as well.
Off the Record will return on WYSL. Thanks so much for listening. Get the podcast, by the way, at WYSL1040.com.
Anyone can build a website these days using all sorts of free tools and services. But do those websites actually get results? And how do you even measure it? Nothing But Net Solutions knows there's so much more to an online presence today. Websites are just one piece of the puzzle. Search engine optimization, pay-per-click campaigns, email campaigns, social media, mobile readiness, and responsive design, plus analytics are all part of it. Nothing But Net Solutions will affordably simplify the choices for you, providing a wide range of internet development and marketing services, all under one umbrella, customized to each situation. Nothing But Net Solutions will be there with you through every step, concerned about only one thing: results. 14 years in business and counting. That's what they really care about. Visit nbnsolutions.com or call 585-298-9510. That's 585-298-9510.
If you're looking to market and grow your business, make new business connections, and give back to the community in a meaningful way, consider joining the Greece Regional Chamber of Commerce. We're the largest suburban chamber in Monroe County, and we offer networking, education, marketing, insurance, and advocacy. You do not need to live or work in Greece to join. Our members come from throughout the region. In short, we're better together, and together, we're moving business forward. Visit greecechamber.org or call 585-227-7272 to join today.
Suffering a serious injury because of medical malpractice, nursing home neglect, dangerous conditions on property, or a car accident can make your life feel like it stands still. How will you provide for your family and overcome this loss? I'm Julie Jordan De Palma. I'm a trial attorney, but I'm also the daughter of someone who suffered a disabling injury. When you need someone to provide compassionate guidance to your family, but be a fearless advocate to your opponent, call the law offices of Jordan De Palma at 585-673-3053.
For breaking news.
Right now, a police investigation is underway in this city.
Police are still working to determine exactly what happened here tonight.
For weather where you live.
A nice chance for some sunshine. Travel overnight into tomorrow will be challenging.
For investigative reports.
We're about to show you the most unique crime prevention story we've ever done.
Who's going to know more about breaking into homes than the people who actually did it?
Watch News 10 NBC. It's where WYSL listeners get their news. Julie Jordan De Palma's Off the Record on WYSL 92.1 FM and 1040 AM. Online at WYSL1040.com.
Well, Julie Jordan De Palma, we're walking on sunshine today.
We are walking on sunshine. It's a beautiful day outside. As much as I would like to say, hey, everybody, listen to the show, I won't lie. I hope for you that if you're listening to my voice right now, you are walking on sunshine and or in your car, looking at the sunshine, and maybe listen to me on the podcast if it's beautiful outside.
With the top down.
You need to go outside, get outside, listen to me on the podcast. I won't take that personally. We are finishing up the show today. We are in our last segment, and we started to move forward on talking about what happens when someone passes away, getting an administrator appointed so that they can wrap up the affairs of the estate. And this is obviously a very technical conversation. We could have whole shows on this. So what I really want to give people is just the 30,000 feet above overview, what to expect and what to think about once someone is appointed. If the will names someone, it's easy to get somebody appointed. If they're still able and willing to serve, that's a pretty easy process for the court to recognize the will and the person that should be serving. If there is no will, someone dies, quote, intestate, they don't have a will that explains these things, then if the assets are such or there's a legal issue that needs to be handled, someone is going to need to be appointed. And again, that is a process that you can initiate with a petition to the surrogates court where the person had resided prior to death or where their property assets are located. And again, it is somebody who is interested in that estate, has some personal knowledge, whether it's a spouse, a child, brother, sister, distributee of some form. And then all of the other interested distributees are going to need to consent to that as well. So that can get trickier for obvious reasons, right? We can all think of the holiday table and how that can be tense sometimes. And sometimes people can agree and sometimes they can't. Sometimes it's an easy process because people say clearly this family member is best to do this and, you know, not it. I'm glad they're going to handle it. And other times there's a dispute, but you can work through that and you get someone appointed. So then now what? What do you have to do? One, you have to get your certified death certificate to accompany that petition for the obvious reasons. You need to be putting on the record that someone has passed away and the date of that death so that it can get someone appointed. And again, that person is a fiduciary. As the administrator of an estate, you too are acting in a fiduciary capacity. And what are some of the things that you have to do as that fiduciary? Well, you've got to preserve and protect and distribute the assets of the estate. You need to properly pay creditors. You need to properly distribute any remaining assets to the people that are entitled to those assets. You have to identify them and make sure people get what they are entitled to get. So let's talk about that creditor piece first. How do you do that? Obviously, you're going to know various bills, or you should know. You're going to want to gather up all those types of bills. You're going to want to gather up all the things that people were responsible for. If they were in nursing homes or hospitals, you're going to want to get the bills from those facilities, those final bills. Estate attorneys help you with all of those things, but as the family member, you have to be able to properly identify those potential creditors. Then there are also other means. Creditors can, part of the reason you open that estate and get someone appointed and you do certain notices is to put creditors on notice that they need to file against an estate and raise their claim in court so that it can be recognized. So how long does all of this take? Once someone passes away and you have a will, it can be a little bit easier. You can get someone appointed fairly quickly. If you don't have a will and you're going through the process of drafting a petition and getting waivers signed by people to agree, that can take a little bit longer as you're getting through the petition and then also as you're tracking down family members to get those waivers signed or getting notices out to them to appear at a hearing to try to determine that if people are not consenting. So if there's no will and you're going through that process, you know, that could take a month to 3 months or more to contact and track people down to do that. Once somebody is appointed, though, what are some time frames? You know, within the first month to 2 months, that person could really be working with the estate attorney to just identify things. What are all the assets? What are all the accounts? What are the various places where people had assets located? Property, finances, bank accounts, retirement accounts, life insurances. All of those things, where are they and have they properly been tapped into, identified, and do we have accountings of what was held in each of those things? Estates in New York State have to be left open for a minimum of 7 months for creditors to identify themselves and kind of raise a hand that they have a potential claim. So you're going to need to hold an estate open at least for that long. 7 to 9 months is a typical time frame for that. You're going to want to notify all the creditors. There's also a New York State tax waiver that often needs to be requested, and that is to determine that there are not any outstanding tax obligations that are out there. And that's not just income tax or estate tax, that's also sales tax, just about anything that the New York State could collect from a person. They're going to make multiple searches when you ask for that tax waiver. And again, an estate attorney can do that for you and will do that for you. But it's to make sure that you do not leave anyone out, because as everyone can imagine, if you leave out a creditor and you don't pay them, bad things can happen.
You don't want that.
Bad things can happen, including that you're still going to owe that money, but in many contexts, you're going to get hit with penalties and significant issues for not paying someone properly, and that exposes the estate and the fiduciary to liability. So you don't want that to happen. You want to be open and honest and find everybody and leave no stone unturned with your attorney, because you don't want that to happen. You don't want anybody coming back and knocking on the door. You're going to need to deal with federal estate tax returns. Depending on assets in the estate, how that will be handled can be different. But for example, federal estate tax returns have to be considered. Federal income tax returns have to be considered. All of those things need to be properly completed and filed. You're going to need to then, once all of that is done, pay and distribute those assets. People oftentimes have questions. What's an asset of the estate and what's not? Again, this could be a show, but simply speaking, life insurance, for example, is not an asset of the estate. It passes outside of the estate. What does that mean? Creditors can't get at that life insurance amount. Similarly, retirement accounts or accounts that are joint accounts, a surviving spouse's bank account with a spouse, for example. Things like that are not all going to be open to creditors, and there's very specific rules about what creditors can attach to be paid and what they cannot attach to. So again, individuals need to identify those trusted advisors in their life who are both going to set up estate plans for them and wills, but who are also going to walk them through this process. This is not a process that you want to navigate on your own, because there are too many pitfalls and things that you just wouldn't know about if you weren't handling this on a regular basis. Similarly, the average attorney out there who doesn't do this regularly isn't the person that you want to research and have help you. Don't just get any attorney that you're friends with to try to help. As much as they want to help you and probably can figure it out, it's probably not in your best interest. You're going to want to find somebody who does this on a regular basis, who knows all the rules, who will cross all the T's and dot all the I's and help you in an appropriate way. And then once all of these things are done, and an estate attorney looks at it and reviews it and knows that everyone's been paid and all of those interests have been protected, they'll help you distribute those assets. And then once all of that is done, you can close the estate. And the fiduciary can sleep at night and know that their job is done. How long is that going to take?
Sounds daunting.
It is. It is a lot. It doesn't need to be daunting if you have the right advisor. You'll walk through that just fine. But you are looking at 9, 15 months at the earliest piece. If you have litigation that's involved, for example, if someone has called me and they have nursing home cases or personal injury cases and wrongful death cases, you can't close the estate while those litigation claims are pending, because any potential recovery from those is, at least portions of, are considered an asset of the estate. So conscious pain and suffering claims for someone before they died, those are assets of the estate. So if you have litigation claims out there for an estate, that's going to keep this tied up longer where you can't close it yet. So all things to consider. And why do I tell you all of these details? Not because I want folks out there to be navigating it on their own, but because I want them to know the questions to ask so that they can do the right research, they can find the right trusted people to help them. And so my plug today is for the fellow peers out there who are estate attorneys, and there are many, and they are wonderful at what they do. Identify your trusted advisors. That's the point of all of this. Identify trusted agents to help you with powers of attorney and your healthcare proxy, and get the trusted advisors out there to help you navigate estate planning, tying up estates, and handling your affairs so that when difficult situations arise, it makes it easier to handle. Have a great weekend. Enjoy the sunshine.
See you next time on Off the Record. Thanks for listening.